Hello, I'm Aaron Delgado. I'm a board-certified criminal trial attorney, and I'm the proud owner of this bad boy, the .50 caliber Smith & Wesson Magnum, the most powerful handgun in the world, with all apologies to Dirty Harry.
But Ian, this is a .44 Magnum, the most powerful handgun in the world, and would blow your head clean off. You've got to ask yourself one question. Do I feel lucky? Well, do you, punk?
Today I want to talk about Florida's Stand Your Ground law. Florida's Stand Your Ground law continues to evolve and continues to be a source of a great deal of misunderstanding. There are two aspects of the Stand Your Ground law I want to talk about. One is the substantive part, what you, a citizen, needs to know, and then the other is the procedural part, what the lawyers need to know and how that could impact you as a citizen. I had the pleasure of teaching a concealed weapons class and also teaching some gun enthusiasts a little bit about handguns and the law. And invariably during the question and answer session, there's a lot of discussion about taking someone's life and under what circumstances you would be legally justified in taking someone's life. Self-defense is what's called an affirmative defense. It means you admit what happened, but you have an excuse, justification, or legal rationale for why you did what you had to do. Classic examples of affirmative defense is necessity. I had to do it or else something bad would have happened. Duress. I did it, but I did it because they made me do it. Self-defense is I did it before it was done to me. All of these defenses require you to admit that it was you that actually did it and that what the other side is saying happened. It's an admittance and then avoidance of consequences because of a better or legal rationale for why you did it. So self-defense comes from the premise that you don't have to allow yourself to be harmed. Initially, there was a sense of proportionality in stand your ground in self-defense. If someone hits you with their fists, you could use your fist back. A deadly weapon would authorize a deadly weapon. But if someone pushed you, you weren't allowed to pull out a gun and shoot them. That has evolved. Further, in the past, the stand your ground laws were strongest in the home. You may have heard of the castle doctrine, which recognizes the home as one's castle and gives you unparalleled legal rights in your castle. Historically, you had a duty to retreat from an attacker until you could no longer do so. Then and only then were you justified in the use of... The exception to that was in one's home. You never had to retreat from an attacker in your own home unless the attacker was someone else who had an equal right to the house, a spouse, a guest. When the Florida law changed, it removed and modified the castle doctrine in many important ways. One important distinction was you no longer had a duty to retreat anywhere before you could meet force with force, including deadly force. This led to the shootings at theaters, gas stations, convenience stores, parking lots, as people no longer felt a need to back down from an escalating conflict. Throughout this video, I'm going to talk about what you're legally justified in doing, but I want to take a moment to talk about the difference between legal justification and moral justification. My personal belief is that if you take someone's life, there are going to be consequences that you have to bear, not just legally, but emotionally and perhaps spiritually or morally. And so I think that before you decide to carry a handgun or before you decide to put yourself in situations where it's possible you might have to use deadly force, I think you need to be prepared emotionally, intellectually, and spiritually, not just for the legal consequences, but for the other consequences of taking someone's life. When I teach these seminars, invariably I'm asked questions about under what circumstances you can use deadly force. One hypothetical that comes up a lot is that you return to your home and you see a young person removing a television from your wall with a screwdriver. They're in the midst of an armed burglary. The screwdriver could be a deadly weapon. Could you shoot them in the back? The questioner will point out that you're in your home, that there's a presumption that because the person is committing a violent felony, that you would be in fear of your life. The screwdriver, as I've said earlier, could be a deadly weapon. I think in those circumstances, there is great potential for violence, and therefore you had a reasonable fear, and that your decision to fire was one of self-defense. Personally, I would not take that shot. I would hold the person at gunpoint and call the police if at all possible. If they lunged at me, that would be a separate thing. If my family was somewhere else in the house and I wasn't sure about their safety, that would be another thing too. But The law does permit you to use deadly force when you're confronted in a situation like that with an armed person committing a violent felony inside your home. That's to me the perfect example of the difference between what you can legally do and what you should morally or emotionally do. And that's the litmus test I propose you ask yourself. If you're going to carry a concealed handgun, I think you need to be versed not only in the law of self-defense, which includes stand your ground, but you also need to be thoughtful and have considered, are you willing to fire your gun? Are you willing to pull your gun and end someone's life? Because as they'll tell you in any handgun class, don't take your gun out unless you absolutely intend to fire it. Because once you take that gun out, you've escalated the situation to a whole new level. And if you don't use it, it could very well be used against you, or someone else could shoot you. The problem with stand your ground law, it's going to be viewed in hindsight by other people potentially seeking to find fault with your decision. No one is going to be standing in your shoes ever again when you make that decision. But it's important that you be able to articulate why you felt that it was necessary for you to defend yourself. Factors that people are going to take into account are going to be common sense things like relative size, disposition, things like that. But the reality is, in that split second, you may not have time to think about all those factors and only just react. That's why self-defense can be so problematic. The reality is, even if you act in self-defense, you will probably be arrested, or at the very least, the area will become a crime scene, including your home. Your handgun or other weapon will likely be confiscated, and you may not get it back for months, if not years. You will likely need legal counsel. You may be accused of a crime. You may face a civil action. In short, that decision is going to have a lot of consequences and ramifications to you far beyond that decision to fire the gun. Florida's Stand Your Ground law gives you immunity from criminal prosecution and civil liability. Civil liability simply means you cannot be sued if you acted in self-defense. That's important because if you shoot someone and they don't die, they could sue you for the damages that were inflicted. And if you're not found to have acted reasonably, you could, believe it or not, be held liable and have to pay for the injuries inflicted on your would-be assailant. However, for most people who are in a true self-defense situation, civil liability is the least of their concerns. It's a life or death situation for them. A good example of that is the popcorn shooting. A man had popcorn spilled on him in the theater and responded by opening fire, reasoning that the popcorn had been a battery on him and that he was acting in self-defense. Whether or not that case ultimately resolved in a favorable way is beside the point. What is important is that person interpreted or believed that Florida law justified his use of deadly force in a situation where he was hit with hot buttered popcorn. So if you take nothing away from this video today, I want you to take away the fact that just because you can claim self-defense doesn't mean that it's a get-out-of-jail-free automatic success. Just because you say self-defense doesn't mean you won't be arrested, doesn't mean you won't be prosecuted, doesn't mean you won't be sued. The best way to avoid the criminal system is just simply not to break the law or be accused of breaking the law, which sounds silly, but when you're talking about self-defense, if you just turn and run or get in the car and drive away, then there's almost no question you won't need a criminal defense attorney. If you stand your ground and punch back or push the guy back or shoot the person, then yeah, you may need a lawyer. You may not ultimately be convicted, but you'll probably need a lawyer along the way. So if you're risk adverse and you want to know the absolute best way to avoid meeting a lawyer like me, then hey, get as far away from the violence as you can and practice avoidance. That being said, there are times and circumstances where you simply cannot avoid it, and I've preached enough about the morality of when you should and shouldn't do it. So if you've decided in advance that that's the route you're going to go and you've been in a situation where your only choice was self-defense, how do you play the cards out from here? So the first thing is you don't want to talk to the police. I've said this over and over and over again. And you may say to yourself, but Aaron, how do I reconcile telling them it's self-defense with your advice not to talk to the police? Don't I need to tell them that right away? Yes, those are two concepts that can be difficult to reconcile. But what's my other constant source of advice? Call the lawyer. If you've decided that you're someone who's capable of using violence in a situation, and moreover, if you're someone who says, if I'm confronted and I'm willing to take someone's life to defend my own life or my family's, then you should have a lawyer. You should absolutely have a relationship with a lawyer if you carry a handgun. Whether you're a police officer or not, you need a relationship with a lawyer. If you have no other choice, if you're the one who has to call 911, then keep it short and simple. Say, this is Aaron Delgado. There's been a shooting. It was in self-defense. Please send the police to 123 Evergreen Terrace, Springfield, Massachusetts, or whatever the case may be. The police arrive and you still have a weapon. You need to put the weapon on the ground. You need to step away from the weapon. You need to show your hands. You need to make sure that the police know that you're not the assailant. You're not armed with a deadly weapon any longer, and that you're not a threat to them or anyone else. Comply with them. They may detain you temporarily. They may handcuff you. That's an indignity that you'll just have to endure. It's probably best that you be compliant and calm as possible during these initial moments. If they ask you what happened, you need to say, I'd like to speak to a lawyer. If you feel confident, you can say, listen, this was self-defense. Beyond that, you need to speak to my lawyer, and you need to invoke your right to remain silent. That's the most valuable thing you can do. And yes, you may think it's contradictory to say self-defense and ask to speak to a lawyer and remain quiet, but the truth of the matter is, if you've been in a situation like that, your adrenaline is going to be spiking, your whole body is going to be in fight or flight mode, and you're in no position to respond to elaborate questions from someone who may be looking to find fault with your decision. If you've been in an altercation and the other person isn't dead or critically injured, and the police are going to talk to both of you, then it's even more important that you ask to speak to a lawyer before you get into a game of he said, she said. If you have any doubt about how important it is to talk to a lawyer, consider any story you've ever told someone else and then what you've heard back about that event. It's always distorted. Now add into that adrenaline, violence, the law, and the police. And it's very unlikely that what you're meaning to say is going to be accurately transcribed and reported as what really happened. If you've used self-defense, you're going to either be arrested or released pending further investigation. If the case is overwhelmingly clear-cut, you may never have to face any kind of prosecution. The other option is the police may make an arrest on the scene. They may not believe you. There may not be enough information for them to make the decision that they think they need to make. In that circumstance, then of course you're going to want to speak to a lawyer. Pretty much, I think if you've been in a self-defense situation, the very next day you need to make an appointment to speak to a lawyer just to give them an overview of what happened, give them your side of the story, and try to understand what your options are going to be in a fact-specific way going forward from there. Let's assume that the worst has happened and you're in a self-defense situation, someone's dead, and you're now being prosecuted. Your lawyer is going to talk with you about your options, and the most important option is the right to have a stand your ground hearing. A stand your ground hearing is a mini trial. You have to make an initial showing that you acted in self-defense, and pretty much all that means is your lawyer has to file the motion. And then the burden will be on the state to prove that it wasn't self-defense by clear and convincing evidence. It's at that time that anything you said or did without the advice of your attorney is going to come back to haunt you. If you win the stand your ground hearing, the case is over, you're immune from further criminal prosecution, and you're immune from civil liability. If you don't win the stand your ground hearing, you can still present self-defense to a jury. Self-defense at a jury is different. It goes back to that affirmative defense. The jury would be told that if they find you acted in self-defense, then the state has to prove it wasn't self-defense beyond a reasonable doubt. And the self-defense instruction at trial is available in circumstances where stand your ground is not. For example, if you're breaking the law yourself, you can't use stand your ground, although you could use self-defense at trial. So the typical scenario is someone goes to buy drugs, a fight breaks out, someone is killed. Can you use self-defense in that circumstances? You can't use stand your ground because you were breaking the law, but you can use self-defense at a jury trial. So that's a quick overview of the stand your ground process and the alternative of self-defense at trial. Honestly, it's a circumstance you hope you never find yourself in. There's really no winning in a circumstance like that because no matter what the legal outcome is, it's going to be costly emotionally, costly financially, costly spiritually, and it's not a route that I would wish anyone to go down unless it's absolutely necessary. That being said, if you or someone you know has been accused of a violent crime and self-defense is your defense, then you need the best criminal defense lawyer you can find. So don't be afraid to give us a call if you need any information about self-defense, stand your ground, or Florida law in general. As always, thanks for following this channel. If you like the content you've heard, please click the subscribe button or click the like button for this video. Thank you very much. See you soon.